Good morning. Welcome to you all. Ambassador Paul van den Ijssel, Ambassador Kanu, State Parties representatives on the review mechanism, good afternoon to you all. I understand that the chair of the IR expert, Mr. Richard Goldstone, is also following us online. I hope he's there, and maybe also Mr. Ian Bonomi. It's always a pleasure to have them in our meetings, and we are always grateful for their continued interest and support to the work of the Assembly on the review process. So, good morning to everybody. Court focal points, staff union, council, representatives of civil society, the ICCBA, and all relevant stakeholders. I declare open the 9th meeting of the 22nd session of the Assembly of State Parties, which is dedicated to Agenda Item 13, Review of the International Criminal Court and the Rome Statute System. It is my pleasure to preside over this meeting, which will consider this issue of great importance of the Court, the Assembly, and stakeholders, and has become increasingly evident over the past years. I very much look forward to hearing your views on the review process and the future of the review. I would like, before I give them the floor, first use to this opportunity to deliver some brief remarks. Because throughout these 3 years of my presidency, the review process has been the top priority for the Assembly of State Parties. This review that was launched in 2020, following an urgent call of 4 former presidents of this Assembly, has been the most ambitious project undertaken to strengthen the Rome Statute system since the creation of the Court. We can all be satisfied that we bring it to near completion this year, in which we mark the 25th anniversary of the adoption of the Rome Statute. The amount of work that has been accomplished is indeed enormous. While the assessment of only few recommendations is still pending, many more have been assessed, and some have already been implemented or are in the process of being implemented. There is no doubt a great deal of progress has already been made. However, the review process is, of course, work in progress, as the building of the Court itself, and some aspects of it may never be finalized or may need perpetual review, such as governance or work culture. The question is how to continue deploying our efforts, and more specifically, how to continue this review process. How to continue the work has been part of our discussion since last year. I recall that at the 21st session of this Assembly, the review mechanism launched a discussion on the future of the review mechanism, which has continued in 2023, assisted by the options put forward by the review mechanism itself. I understand that following consultations, it is envisaged to continue the work of the review mechanism for at least 1 more year to finalize pending matters, including tenure. I commend your commitment to strengthen the system and wish you a fruitful continuation and completion of your work in the coming year. As I will not be accompanying this continuation of the efforts, I wish to use this opportunity to express my recognition to all those who took part in this ambitious undertaking within the Assembly, the Court, and civil society. I thank them all for their active participation in the inclusive and transparent dialogue that allowed the review to move forward. I commend the Court, in particular, an essential partner in this complex exercise, for its crucial contribution and proactive approach to the recommendations of the independent experts. I know that it was not always easy to reconcile its demanding work at the Court with the need to provide inputs to various issues and take part in the meetings of the review. Without the court's commitment and contributions, the review would have not been possible. So thank you. My special recognition goes to the leaders of this process, the special representatives dedicated to the review, Ambassadors Michael Canu and Paul van den Eysel, who led us all in this difficult journey with the assistance of the country focal points. I also wish to recognize the important work done by the Assembly mandate holders in support of the review mechanism. They have all contributed to significantly advancing the work of the Assembly on the independent recommendations. And last but not least, I wish to express on behalf of the Assembly our gratitude to the independent experts themselves for their hard work in producing an impressive set of sound recommendations for us to work upon. I also commend them for their willingness to continue to assist the process by participating in the meetings in order to provide background and information on their thinking in relation to the recommendations under consideration. Their helpful presence was welcomed by state parties and other participants. And to conclude, I also thank the Secretariat that assisted this exercise, also in addition to its many other tasks. I encourage you all to continue the good work in the future. So I thank you for your attention, and now I invite the state parties representatives on the review, Ambassador Paul van den Eysel and Canu, to deliver some remarks on this topic. Ambassador Canu, you have the.
Thank you, Madam President, for the floor. Thank you for your important remarks, really reflecting the important work that has been done in the review process so far. But the collaboration between yourself as President, the Presidency Review Mechanism, the mandate holder and Secretariat, but importantly, stakeholders and state parties were also quite active. In delivering this short remarks, I will start. Co-Chair Ambassador van der Eysel is struggling with his voice a bit. He will come in during the process, but he has asked me to deliver this initial opening remarks. So I thank you again, Madam President, for the floor, and thank you for your very kind and insightful remarks. It is our honor to welcome you and have you make very valuable remarks in this plenary of the review of the International Criminal Court and the Rome Statute system. We appreciate the strong support we've always enjoyed from you as President, and indeed all state parties, the court, civil society, and all stakeholders. We recall that you've indicated on a number of occasions how important the review is for the court, state parties, and all stakeholders. And given your long-standing and special link with the court, we know that you take this issue very much to heart. Thank you so much. Excellencies, distinguished colleagues, we also wish to welcome our IAR experts who were also quite valuable, not only in putting out the report, but making themselves available during the work of the review mechanism and assessment of the recommendations. I understand that Mr. Richard Goldstone and Mr. Air Bonomi are with us, so thank you for joining us. Colleagues, we came to this ASP with a proposal to end the work of the review mechanism and give our responsibilities back to the Assembly. The continued work on the review should take place in the regular facilitation. That was the view. We also noted that the work on the review is far from over. Although we, except for one or two recommendations, have completed the assessment of the 384 recommendations. Implementation is still very much underway, and in some cases even have to start. As it is, of course, in the implementation where it will be decided whether this review operation is a success or in the end it stays a bureaucratic and paper exercise. We also pointed out that there may be a need for filling some gaps in the system, like monitoring the implementation of recommendations on the Trust Fund for Victims, relations with civil society, and others. We suggested that in order to have a comprehensive covering of the implementation of these topics, this could be added to existing facilitation or a new one could be created. As the Assembly is aware, we now decided to prolong our life with 1 more year. And I think it's a decision of the Assembly to prolong our life for 1 more year. But we think it should be 1 year only. In that year, the review mechanism will continue to monitor the implementation, and if need be, will organize sessions to discuss implementation. We will keep the metrics updated so that all stakeholders can see where we are. On top of that, the review mechanism will also facilitate the discussions on the modalities of the introduction of the tenure policy as of 1st January 2025. When we come to this session, we are aware that there is a list of speakers. We encourage you, even if you have not inscribed, to take the floor to make points that you may wish to raise on the progress of the review and the work of the review mechanism and its future. You will recall that at the first plenary meeting of this Assembly, we introduced the report of the review mechanism on the review process, submitted pursuant to the mandate of the Assembly. We reported that the review mechanism had held 7 meetings in 2023, 2 as a platform for discussion to focus on the assessment of remaining IR recommendations, 4 roundtables and 2 meetings to discuss a recommendation that had already positively assessed in 2022, that is recommendation 105 on tenure. The review mechanism completed the assessment of the recommendations which he had assigned itself as a platform for discussion in a comprehensive action plan. The review mechanism allocated recommendations to different facilitations as a platform for discussion. We welcome the work of the facilitators on the IER recommendations and are grateful that they have made good progress and in many cases completed the assessment of the recommendations assigned to them as a platform for discussion in the comprehensive action plan. As regards the metrics on progress in the assessment of the IER recommendations, we plan to circulate it as soon as possible. The idea of the matrix is to give an overview of where we are in the review process, both on assessment and on implementation. The matrix will be included as an annex to the report of the review mechanism submitted to the ASP. We would like to once more highlight that the matrix is a living document which we intend to update regularly in order to provide a regular overview of the state of the review. Madam President, thank you again for the floor, your leadership, and I yield back the floor to you. Thank you.
I thank you. Ambassador van den Eyssel, would you like to add any remarks?
No, thank you. Michael said everything I think we can say at the stage. And I only want to join him in thanking all those who were involved, including the IAR experts who are following us online, I'm told. And I hope at next meeting my voice is a little bit better. Thank you.
I thank you. So then I would now like to invite the court to make some remarks. Mr. Hirad Abtai, you have the floor.
Thank you, Madam President. So as you mentioned, 3 years, it took 3 years between September 2020 and let's say November 2023 for the court to, together with under the auspices of the ASP, of course, to assess those recommendations, all of those that were assigned to the court. These recommendations really concerned, they were sometimes court-wide, sometimes organ-specific, and sometimes thematical to the core mandate of the court, for example, cooperation, victims issues, defense matters. Madam President, as you mentioned, the work was enormous. there are 384 recommendations spread across 348 pages. I always saw this as a numerical anagram. The process has shown, as far as the court is concerned, in our opinion, governance in action. Not only governance within the court itself, between the different organs and the trust fund, Articles 38, 42, and 43 of the statute. And in this regard, I must say that working with Racine and Juan, the focal points of the OTP and registry, respectively, has been a pleasure. But it's also been, and this is important for us to state, that the process has shown governance within the broader Rome Statute system under Article 112(2)b of the statute, according to which the ASP provides management oversight to the presidency, the office of the prosecutor registry, the prosecutor registrar, and regarding the administration of the court. We hope that these 3 years of unprecedented synergies between the ASP and the court have reinforced trust between these bodies. We look forward to reporting on those recommendations that are yet to be implemented or that are being implemented. And last but not least, we would like to thank Ambassadors Van der Nijssel and Kanu, as well as the ad hoc country focal points for the leadership and the Secretariat of the ASP for its support in the conduct of this process. Thank you.
I thank you very much for your remarks. I give the floor to Ms. Umu Ba from the Guinean National Coalition for the CICC. Ms. Ba, you have the floor.
Merci, Madame la Présidente.
Thank you, Madam Chair. Since the review mechanism was launched, the civil society, notably the International Coalition for the Court, has made a package of recommendations to discuss the relevant priorities to ensure that priority actions can be taken. I would like to thank the Secretariat of the ICC and the advocacy team for all of the efforts that have been made to allow civil society to participate in the virtual dialogues with members of the review team, and we have had a frank and cooperative discussion. The implementation of the 300-odd recommendations will make it possible for us to strengthen the work of the court to ensure that we can have universal, impartial justice to put an end to impunity for serious human rights violations throughout the world. Our coalition takes part in the review meetings. We provide inputs into the discussions to try to move the process forward. There is currently a high-profile trial underway in Guinea, and the court has played a significant role in this process. Thanks to the various reviews to look at the progress that has been made, including the progress that has been made at the domestic level in Guinea, as a result of this, victims have been able to achieve justice and get reparations. That is why we do wish to commend the progress made in the implementation of the recommendations through the review processes, and thanks to the ambassadors who are leading the process. The International Coalition for the ICC has been particularly engaged in the process on the recommendations to increase awareness about the court's work in civil society. Civil society organizations are often at the front lines to bridge communications gaps with affected communities. Based on the recommendations that experts have made, the court should come up with further awareness-raising strategies that are tailored to the individual contexts. The ICC's engagement with local media and journalists is also an important way of ensuring that correct information is shared with the wider public. States parties should ensure that the court has the necessary resources to facilitate effective awareness raising. On the inclusive nature of the review mechanism, civil society, including the Guinean coalition, have been committed within the review process from the very beginning. We need to ensure that there is continued access to the process so that we can keep up this engagement from civil society, which is so important to the entire process. The Guinean Coalition for the ICC and the other Francophone Africa coalitions will always support this process to try to provide visibility to the work that the review mechanism is doing in Guinea and in Africa. Thank you.
I thank you. And now we will give the floor to you. The first one on my list is Finland, Ms. Berna Atkins, legal advisor at the Embassy of Finland, The Hague, on behalf of the Nordic state parties, Denmark, Finland, Iceland, Norway, and Sweden. Ms. Atkins, you have the floor.
Thank you, Madam President. I have the honor of speaking on behalf of the Nordic states parties, Denmark, Iceland, Norway, Sweden, and my own country, Finland. The review process has been an immense joint effort. We wholeheartedly thank the review mechanism, the state party representatives, and the country focal points for their work and guidance in the past years. We extend our appreciation for the Assembly mandate holders and the court focal points. We welcome and commend the court's efforts and engagement in the process. As we near completion of the assessment phase, our focus will be on implementation. This is a crucial, if not the most important part of the review process. We need to find the best ways of overseeing implementation, guided by efficiency, transparency, and inclusiveness. We thank the review mechanism for the latest report and for the non-paper on the future of the mechanism. The Nordic countries share the conclusion of the paper that the mechanism has fulfilled its mandate. However, we support the compromise achieved to extend the review mechanism by 1 additional year. Moving forward, we wish to see implementation oversight become part of the regular work streams and structures of the Assembly of States Parties. It would make sense to utilize, to the extent possible, the existing ASP structures in overseeing the implementation of individual recommendations and the overall progress. The respective facilitations could take up the responsibility for follow-up on implementation. Recommendations that were assessed under the review mechanism should primarily be allocated to existing facilitations. Alternatively, some key recommendations, such as those related to workplace culture, could be addressed directly under the working groups. The Bureau could have responsibility for overall monitoring with the support of the Assembly Vice Presidents. Madam President, the Nordic countries place particular emphasis on an inclusive and healthy workplace culture, staff well-being, and gender equality. We acknowledge the efforts of the court so far and encourage continued commitment and steps towards concrete results. We note with concern some of the recent findings of the IOM. Overall, we call on the court's leadership to engage meaningfully with staff. We believe that active participation by staff in the implementation of recommendations, including through the Staff Union Council, is key to sustainable results. The Nordic states parties remain committed to the review process and to ensuring that the ICC and the Rome Statute system are optimized to deliver on their core mandate of fighting impunity and delivering justice for the victims. Thank you.
I thank you for your remarks, and now I give the floor to France.
Mesdames et messieurs,
Ladies and gentlemen, since the very beginning, France has been convinced of the importance of carrying out the audit of the only permanent jurisdiction to try the most serious international crimes. We would like to commend the review mechanism and the focal points for the enormous work they have done, and we welcome the commitment of the court's bodies. France welcomes the implementation of the priority recommendations, which clearly shows the importance of continuing this work. We would in particular like to highlight the importance of verifying the candidacies for the elected posts as early as possible before the elections, and to do so permanently. In addition, the adoption of a tenure policy is also a very important step forward. France welcomes the Siracusa Declaration, which was adopted in October, on the strategic vision of the ICC for the next decade. This declaration will help to implement the recommendations made by the independent experts. It invites states to foster the development of specialized training on international criminal justice where this is most needed. An example of this is the REACT project, the Regional Atrocity Crimes Training Platform, which is led by the Siracusa Institute and supported by France. This aims to bolster capacity building at the national level. The declaration also notes the ethical guidelines and principles for international judges, and they were adopted on the 15th of May this year in Paris. These 25 principles are part of a justice system that must be beyond reproach and must be of the highest moral standards and be a benchmark which will now be included in the Omnibus resolution as a guide for all international judges going forward. The review mechanism has almost completed its mission, and it has fully shown its effectiveness. We welcome the fact that its mandate is being extended so that we can finalize what has been achieved. Madam President, I would like to assure you of France's unwavering commitment to support the court's progression to make it stronger, and this important tool is part of this, that is to say, the review mechanism. Thank you.
Je vous remercie.
I would like to thank you
To Ms. Tom Barwick, Deputy Head of International Justice and War Crimes of the United Kingdom of Great Britain and Northern Ireland. Mr. Warwick, you have the floor.
President, for giving me the floor. On behalf of the United Kingdom, I'd like to thank Ambassadors Van Ysel and Kanu for the continued excellent work as State Party representatives on the review mechanism. I'd also like to thank Bangladesh, Chile and Poland as country focal points, the court focal points and the ASP Secretariat for all the support it has provided to the review mechanism. This year is an important milestone in the review process. We congratulate the review mechanism for its role in assessing all but a few of the 384 recommendations. As we further move into the implementation phase of the review process, we must build on that momentum to fully implement all positively assessed recommendations. As a committed supporter of review, the United Kingdom has engaged closely in discussions on how we best achieve what is a shared goal. We now have clarity on the way ahead, and that's to be welcomed. The United Kingdom welcomes and supports the review mechanism's proposal to extend its mandate to oversee the implementation phase of the recommendations. It's right that we build upon the expertise and experience that has been accumulated over the last 3 years, and we're delighted that Ambassadors Van den Ysel and Kanu have agreed to remain in their roles. Furthermore, we welcome the review mechanism's appointment to lead work finalising a tenure policy for the court to be introduced on the 1st of January 2025. This is one of the crucial recommendations to bring further new ideas and creativity into the court. We look forward to continuing to work collaboratively with states parties for court and civil society to ensure that the ICC remains a dynamic and effective institution, best able to ensure accountability. Thank you.
I thank you, and I give the floor to Mexico.
Thank you very much for giving me the floor, Madam President. We acknowledge the work undertaken by the review mechanism to implement the recommendations contained in the report of the group of independent experts. This year, we have made progress on evaluating almost all of the recommendations. We'd like to thank the co-chairs, Ambassadors Michael Canu and Paul van Ijssel, as well as the focal points from Chile, Poland, and Bangladesh. In addition to the ASP Secretariat, we'd like to thank them all for their efforts. We think that the extension of the mandate for 1 year is suitable. It will allow us to culminate the assessment of the recommendations and continue the implementation of the recommendations that were positively assessed and all those that have been amended. In 2023, we stress the significant progress that has been made on recommendations on work culture, the mandate system, the trust fund for victims, as well as the participation of victims in the court's processes, remedies, the strategic vision of the court for the next decade, relations with civil society, inter alia. As we look forward to next year, we would like to express our interest to move forward on the outstanding recommendations which will allow the Rome Statute system to be more efficient and to allow us to achieve our goals. We think we need to focus in particular on recommendations on the working culture. On this issue, there is a lot to do. It's deeply concerning to see that in the report there are 35 new cases, and 20 of which are related to bullying or harassment at work. And we reject entirely this kind of behavior and conduct, which cannot continue to happen. We must find the necessary ways to disincentivize this kind of conduct. The court must be a safe place to work for all staff. Mexico will continue to try to make sure that there is an appropriate, respectful working climate in the court. The implementation of the recommendations has been a joint effort for all of the court's bodies, as well as states parties as a whole, in addition to civil society and the facilitators. Madam President, Mexico has been actively involved in the process since the beginning, both in the working groups in The Hague and New York. Next year will be the same. Mexico will continue to work to try to ensure that we can culminate this important process, because over the last 3 years, significant results have been achieved. Thank you.
Muchas gracias a México.
Thank you.
Or to Ms. Paulina Ducik from Poland.
Madam President, distinguished delegates, Poland, as a member of the review mechanism at country focal point, has the privilege of being closely involved in the review process from its very beginning. As the assessment of the recommendations of the independent expert review is practically finalized, with just a few exceptions, and the implementation of the positively assessed recommendations continues, we can now make a preliminary assessment of our joint achievements. In 2023, the focus has already shifted to the implementation of positively assessed recommendations. However, as we have said on many occasions, the review process is not a box-ticking exercise. The review process, especially within the priority recommendations like working culture, is an ongoing commitment that requires a continued engagement on the part of state parties and the court. This ongoing commitment will ensure that the tangible outcome of the review process does not fade, but contributes to improving the efficiency of the Rome Statute system. In Poland's view, one of the most tangible results of the review process will be an introduction of tenure policy, to which we are ready to commit. We believe that an effective and practical system of tenure will encourage fresh thinking and bring more dynamism to the court. Distinguished delegates, we should be practically particularly proud that despite the many pressures the ICC faces, despite the unacceptable acts intended to hamper the court's independent mandate, the implementation process of the IER recommendations has not slowed down. This year has shown that even the challenging circumstances in which the court operates do not make us forget about the need to improve its functioning. What is more, it is because of all these challenges that we should all be even more determined to support and reinforce the ICC so that it can fulfill its mission of investigating and prosecuting the perpetrators of the most serious crimes of concern to the international community as a whole. Poland is truly proud to be able to contribute to this collaborative effort to strengthen the court and is ready to continue its engagement in the review process as a member of the review mechanism. Several delegations generously state that the review mechanism is a victim of its own success. This success could not have been possible without the personal commitment and dedication of many people involved in the work of the review mechanism. At this point, if I may, Madam President, I would like to wholeheartedly thank the review mechanism state party representatives, Ambassador Paul van den Eyssel and Ambassador Michael Kanu, for their able leadership. I thank my fellow at-country focal points, colleagues from Chile and Bangladesh, and of course the court focal points, Hirat, Racine, and Juan, for always being ready to fully support the work of the review mechanism. Last but not least, I would like to express my deepest gratitude to the Secretariat, especially to two people without whom we would not have succeeded. Gail and Aaron, thank you so much. You have provided us with invaluable support and help in fulfilling the mechanism's mandate. Thank you so much, Madam President.
I thank you. And now I give the floor to Switzerland.
Madame la Présidente.
Madam President, apologies. During this assembly, we have had the opportunity to recall the critical role played by the ICC in promoting the rule of law. We have also said that the court needs the unwavering support of states parties to the Rome Statute. This is critical to ensure that we can uphold its independence and impartiality. The expression of Switzerland's unwavering support to the ICC goes hand in hand with our commitment to see the court's effectiveness and efficiency improved. For a long time, Switzerland has been trying to pursue these goals. Between 2014 and 2016, we led the informal process on this topic. We therefore welcome the fact that the Assembly has put the review of the court and the Rome Statute as part of the priorities on its agenda over the last few years. We welcome the review carried out by the independent experts. Their recommendations are a robust framework to strengthen the institution. But the exercise doesn't end with the review of the recommendations made by the experts. Now we need to continue implementing these recommendations. And we call on all stakeholders, including states parties, to be part of this effort. We also recall that this process must at all times respect the independence of the court. Madam President, we are particularly grateful to the review mechanism for its transparent coordination, and we welcome the quality of its work. We would like to thank Ambassadors Van Eyssel and Kanu for their remarkable commitment. We have taken note of the latest report, and we will closely follow the discussions in the context of the relevant resolution. When it comes to the future of the review mechanism, Switzerland can support any solutions that makes it possible to finish the important work to implement the recommendations made by the group of independent experts, while also optimizing the use of resources made available for that purpose. Further support for the court structures in 2025 seems to us to be a good option. I would like to thank you, Madam President, and I would also like to thank you personally for your leadership over the last 3 years, and I wish you the best in your future endeavors. Thank you.
Sorry. I thank you, and I would like to ask whether any other delegation wishes to take the floor. I give the floor to Chile.
Thank you, Madam President. My delegation welcomes the progress that has been made this year in the assessment and implementation of the recommendations made by the group of independent experts, as has been clearly reflected in the report. Although there are still outstanding tasks to complete in terms of implementation, we think that the review process has revitalized the interaction between the states parties and the court itself. We think that the work done by the mechanism is critical to strengthen the court's functioning. That is why we reiterate our commitment to the process, in which Chile has worked as a focal point. When it comes to the future of the mechanism, we support there being an alternative so that the next assembly can rationalize implementation through the work of the facilitators appointed by the Bureau. We think that the non-paper on the future should be borne in mind for the remaining work of the mechanism. We agree with what was said by Mr. Kanu on that point. In 2024, my delegation welcomes the fact that the mechanism will continue to work, and we are available to continue participating in the mechanism as the focal point for the following period, supporting Ambassadors Van Ysel and Kanu and states parties, and we would like to thank the ambassadors for their critical leadership on this topic, and we'd also like to thank the Secretariat, particularly Gail Ramuta, and everyone else for their work. Thank you. Thank you very much.
The floor to Uganda.
Good morning, Madam President. I have the honor to deliver these remarks on behalf of the delegation of Uganda. I would like to thank Ambassador Paul van den Ysel and Ambassador Michael Imram Kanu and the at focal points, Bangladesh, Chile, Poland, for the tremendous work done on the review mechanism. Since its appointment, the review mechanism has carried out the mandates of the 19th, 20th, and 21st sessions with you, Madam President, which you so ably chaired with much dedication. I take this opportunity to commend the review mechanism on its work and for convening this plenary during the 22nd ASP. We note with appreciation the work done by the other assembly mandates, the court's organs, and independent offices on the IER recommendations, particularly on the implementation of the positively assessed recommendations. The issues being addressed today go to the heart of the work of the court, that is, the court's working culture, the strategy to deal with and zero tolerance of bullying, harassment, and sexual harassment, and gender equality and inclusiveness, regardless of gender or sexual orientation, and geographical representation in the recruitment of staff. Having taken note of the presentations, we thank them, the presenters, and wish to specifically highlight the issue of geographical representation in the recruitment of staff. The Rome Statute provides that the court shall ensure the highest standards of efficiency, competency, and integrity, and shall have regard to fair representation of women and men for all positions, representation of the principal legal systems of the world for legal positions, and equitable geographical representations for positions in the professional category. In Resolution ICC-ASP/1/Resolution 10, when the court was established, it allows for non-states parties to be recruited in order to encourage the universality of the Rome Statute. However, this is no longer the case, and the fact that recruitment of non-states parties in the court has been overwhelming to the detriment of geographical representation. And therefore, we plead for a moratorium on the recruitment of staff for nationals of non-states parties, without prejudice to Staff Regulation 4.4, and excluding staff positions not accounted for the purpose of geographical representation, such as language staff. In further noting the relevant provisions of the Rome Statute and Assembly resolution on the selection procedure, we are of the view that equitable geographical representation for positions in the professional category and elective positions have a direct nexus to the universality of the court. We request of the Assembly for the Bureau to continue engaging with the court to identify ways to improve equitable geographical representation and gender balance in professional posts. Let me state that we are also concerned about geographical representation in the Secretariat and other subsidiary bodies of the ASP. We would like the record to reflect that the draft resolution on the tenure policy should not preempt what will be discussed during the facilitation in 2024. We must ensure that the discussions on tenure take into serious consideration the question of equitable geographical distribution and gender balance. Finally, let me state that Uganda is ready to engage constructively to make meaningful progress as we continue the review mechanism. I thank you.
I thank you, and I give the floor to Japan.
Thank you very much, Madam President. At the outset, allow me to extend my deepest appreciation to the State Party representatives, Ambassador Van Nysel and Ambassador Kanu, for facilitating discussions of the review mechanism for the past 3 years. In those 3 years, the review mechanism has built a track record and proved its usefulness through various means. This includes serving as a platform for assessment of recommendations contained in the report of the group of independent experts and monitoring implementation of the assessed recommendations as appropriate. While the implementation of many of the positively assessed recommendations is not completed and in some cases has not even started, the ICC must continue to make steady progress on its comprehensive review. Only by implementing such review will the court be able to function effectively and sustainably. Japan believes that it cannot be properly achieved without the functions of the review mechanism and took its stand in favor of extending the mandate of the review mechanism. Japan appreciates the responsibility taken by the Ambassador Van Nysel and Ambassador Kanu, as well as the co-focal points, and all other parties involved in the process, and assure Japan's contribution whenever it is needed, including the constructive discussions in view of introducing tenure policy, which we place particular importance to. Thank you very much.
I thank you. Does any other delegation wish to take the floor? I see no further requests from the floor, so I will now give the floor to civil society. I first give the floor to Ms. Yasmina Gurshan from the CICC.
Madam President, Excellencies, dear colleagues, I'm delivering this statement today on behalf of the Coalition for the ICC's issue team on the ICC review, which was established in early 2021 in an effort to coordinate civil society efforts around the complex and overwhelming IER process and develop advocacy to that aim. Coalition members from around the world have remained actively engaged in the process since its inception. First, we would like to express our gratitude to Ambassador Kanu and Ambassador Van den Ijssel for effectively and consistently shepherding us through the many recommendations through the review mechanism, and for ensuring the inclusive access and participation of civil society in the review mechanism process via online meetings and the provision of interpretation into French and English. Civil society, and particularly CSOs and human rights defenders from countries where the court is active, bring valuable perspectives to the tables as key stakeholders in the process, as they are first-hand documenters, provide support to victims, and serve as key links with affected communities. They also experience firsthand the shortcomings of the court. They share expertise and best practices on many, if not all, the issues on the agenda of the review mechanism and the review process, in particular on outreach and communications, on victims' rights and participation in proceedings, and complementarity efforts, to give just a few examples. The review process has been a long and comprehensive one. As we've now reached the end of the assessment phase, it will be essential to ensure that the implementation of positively assessed recommendations, as well as the monitoring of their implementation, remains ongoing to ensure genuine progress continues. The next phase of the review process should not be a simple box-ticking exercise ending with the assessment of the recommendations this year. Related, efforts to improve the performance of the court and overall impact of the Rome Statute system should continue indefinitely, building on the progress achieved in the review process thus far. And finally, with the extension of the review mechanism into 2024, we recommend the following fundamental principles continue to guide the process. First, transparency to ensure legitimacy and credibility of the process, including by the regular and consistent communication about progress and next steps made available in different languages, and ensuring the inclusive access of all stakeholders to meetings. Second, and related, inclusive and meaningful engagement with stakeholders. Civil society has been an essential stakeholder in the review process since its conception, a practice which must continue, including by the translation of documents, interpretation in meetings, and organization of meetings accessible to civil society all around the world. Third, and finally, the process must continue to respect the court's judicial and prosecutorial independence and take into consideration the limited resources at its disposition. We look forward to continuing our fruitful engagement with the review process in 2024. Thank you.
I thank you, and now I give the floor to Ms. Maria Elena Vignoli of Human Rights Watch.
Thank you, Madam President. Excellencies, 3 years after the IAR report was published, thanks to the stewardship of the review mechanism, much has been achieved. But efforts to strengthen the court's delivery of justice should remain on the court's agenda in partnership with the Assembly and civil society. As we move forward, these efforts should increasingly focus on state party responsibilities. While states parties have grappled with certain IAR recommendations that bear on their roles, such as those related to governance and elections, there is a need to go further. This should include honest dialogue between the court and the Assembly about the resources needed in the long term to ensure the court can more fully and effectively deliver on its global mandate. While the IAR recommendations were presented as almost resource neutral, the reality is that ensuring the court improves its performance requires investment. IAR Recommendation 363 offers the ideal framework for this type of dialogue. This recommendation was positively assessed and refers to the development of a 10-year strategic vision for the court, backed by a shared understanding of the resources, cooperation, and institutional development necessary to achieve that vision. The Assembly President has already laid the groundwork for its implementation by using this recommendation to frame discussions on the 25th anniversary of the Rome Statute. But this was only the beginning. It is now time to take the next steps. To this end, the Assembly should support the court in developing a 10-year strategic vision backed by consultation with civil society and affected communities. A shared vision is key to ensuring the court can deliver the task that you, its states parties, have set for it heading into the future. I thank you.
I thank you. If there is no further request from the floor, I don't know, Ambassador Wolfgang de Nysel, you have the floor.
Yeah, I think we listen to you with great interest. We will not respond immediately to some of the suggestions, but on behalf of Michael and me, and of course of the Country Focal Point, thank you for your support and your kind words. And as we decided to continue for one more year, because really next year's ASP, I think we have to conclude our work. That doesn't mean the end of the review, of course, but I think then at that time the review mechanism's work should be, as I said, the responsibility should be sent back to the Assembly. But in this one more year, we will certainly need your support, both on monitoring the implementation. You identified already some priorities, and also on discussing the modalities of the introduction of a tenure policy. And if you allow, Madam President, some housekeeping at the end, because I think we've come to the end of the discussion. During this ASP, we have circulated 2 standalone resolutions. One of the work of the review mechanism, which, as has become clear for those who weren't present, included an extension of the mandate for 1 additional year, and a second one on the tenure policy. The second one on the tenure policy was approved under a silence procedure this morning. So therefore, we plan to introduce the draft resolutions at the plenary to be held, I think, at 3 o'clock this afternoon. And we hope that both resolutions, of course, will be adopted by consensus in the closing plenary, which will take place tomorrow. I think that concludes what I wanted to say, Madam President.
I thank you. Ambassador Khanna, would you like to add anything on this? No? Yes? No. Okay. So thank you very much. So that brings our plenary morning to a conclusion. I am grateful to the review mechanism for their willingness to continue their mandate for a further year. And with this, we have concluded our consideration of agenda item 13. I declare this plenary meeting closed. I would like to inform you that there will be informal consultations on the budget immediately following the adjournment of this plenary. These consultations on the budget will be open to state parties and the court only. In addition, and it has already been said by Ambassador Paul van den Nysel, there will be a plenary at 3 o'clock this afternoon for the introductions of resolutions that are ready, including the ones on the review. I thank you, and this meeting is now adjourned.
Okay.
Very good. Very good.
Okay. Lively discussion. Lively discussion. Oh, okay. It's okay for you to stay till 3. I can do it.
Lamento la calidad de los churros. Lamento la calidad de los churros.
¡Qué despelote! ¡Qué despelote!
Acabamos mal.
Pero muy mal, ¿eh? Esto nunca lo olvidaré. Nunca le pones un apestoso al lado.
No me podía aguantar de la risa cuando hablaba ayer. No estaba.
No, y yo me pongo la máscara para proteger a los demás de mi peste. Pero
tiene la suya.
Pero este también.
Viene a la oficina, estaba sentado tosiendo todo el rato.
No, es horrible.
Pero no me podía aguantar porque habla. Sale la voz de pito.
I'm very happy you were well enough to stay for the whole meeting because we were not sure. No, we changed, we were making small changes to the chair notes at the last minute.
Okay, so I had to show that I like, I care. If I care, and let me take this from here. How do you go back to normal?
I haven't been able to get that.
I touched something, but
yes.
need is this. Can always.
Can I please ask everyone to take their seats so we can start the meeting? Thank you very much. Okay, let's start. We are still in the morning, so good morning, everyone. We continue our informal consultations on the proposed program budget for 2024. The first part of the meeting will be with the presence of the court, and then the second part will continue and will be open for states parties only. So while we have the court with us, you received late last night the scenarios we agreed to ask the court at our yesterday's meeting, as well as the proposal tabled by Ireland yesterday and the group of states parties. And also you received approximately half an hour ago, I emphasize it for those who maybe haven't seen it, just the final adjustments to the scenario. A scenario from the court, there was a minor adjustment simply to be as precise with the figures as possible. So please look at that last version that was circulated by the Secretariat some half an hour, 45 minutes ago. So before I open the floor for any possible questions or comments to the court, I would like to give the floor to the registry to give an explanation of the tables that we received. And also in that, I would just add a request for clarification of the security envelope, which was included here. How does it break down across the court? So, Mr. Alipi, you have the floor.
Good morning, Ambassador, and good morning, distinguished delegates. Thank you for giving me an opportunity to present the table. As you mentioned, the table that was submitted at 10:30 includes a further reduction in the travel as per resolution amount impact, column, and that's a reduction that is linked to a further check that has been performed by our colleagues within the system compared to the estimate that we came up with last night. So an additional 8,900 euros. That doesn't make any difference in terms of a percentage increase in the two scenarios. Now, the table is quite complex, and it allows us to capture all the different scenarios that you requested us to prepare for the different major programs. Starting from the left, you can see under the column measure program, all the measure programs of the court with their own budget approved for 2023. Then we have the 2024 proposed budget at the CBF level. So after all the recommendations of the CBF and the reductions recommended by the CBF, which, as you know, is an increase compared to the 2023 budget level of 8.7%. Then moving right, for the registry, following the withdrawal of the charges by the prosecutor and the termination of the judicial proceedings, the registry communicated a reduction in resources for the Mokon case of 943,500, so that's been reduced against the CBF level. There was also a decision in the facilitation of legal aid to have an increase in the envelope for legal aid of 200,000. So that's indicated in the following column as an addition. Furthermore, there was a request to add the resources that were reduced by the CBF for security, and that's an amount of 851,000, which is for cybersecurity, for systems that are utilized by all the offices within the court, by all major programs of the court, and also for physical security. That is in the amount of 420,000, more or less. And that's for close protection to the principals of the court, to the prosecutor when he travels, in his missions to the field and in other areas where close protection is needed, but also for security analysis to assess the security risks that are attached to the various missions of the various staff of the court, be it the prosecutor staff or the defense when they travel to the field, or for witnesses protection and so forth. So that's all included in that 420,000 that has been added as part of 851,000. The following column gives you the level of the travel budget after the CBF reductions for each major program. And on that level, the various scenarios that you requested have been calculated. 10% reduction for major program 1, 2, and 3 that you can see in the following column, and totals 441,000, and 20% reduction. That amounts to double of the previous amount, 883,000.7. There was then a request to present the amount that is equivalent to 2% increase in the vacancy rate for the OTP, and that amount is 944,000, which is a reduction for the OTP in the staff costs envelope if there is a decision to move from 8% currently used for the budget 2024 to 10%. The following column shows a reduction for MP4, the Secretariat of the ASP, and MP6, the Secretariat of the Trust Fund for Victims, following the alignment of the travel policy to your decision or proposed decision within the resolution to move from business class to economy class, and to reduce the DSA from 140% to 115%. The total amount between the two is 135,900. The next column has an increase for the Secretariat of the ASP of 102,400. That is the sum of the meeting for the advisory committee on nomination, should there be an additional meeting, and that's an increase of 22,800, and a position, P3 level, for 6 months, legal officer in the Secretariat of the ASP. The next column includes the resources for 3 positions for the Trust Fund for Victims, the Secretariat Trust Fund for Victims, in a total amount of 122,400, as indicated in the scenario for the Trust Fund for Victims, 1 position in the HQ and 2 positions in the field. So we then come to the totals. Total for scenario A includes all those variances, up or down, depending on the scenarios created and requested by you, with a reduction in travel of 10%, and total B with a reduction in travel of 20%. And the following 2 columns indicate the variance of option A, that is the scenario with a reduction in travel of 10%, against the proposed budget 2023, variance in amounts and variance in percentages. So if you were to go for a reduction of 10% in travel, you would have, considering all the other adjustments, an overall increase of 8.1%. And then finally you have the increases for option B, that is a scenario with a reduction in travel of 20%. And in percentage, it would be an increase of 7.2% against the 2023 budget. So this is the table summarizing all the scenarios that you requested. It's quite complex. I hope it's clear. Should you have any questions, we're at your disposal to address them. Thank you.
Thank you. You have also received, as per request to the OTP yesterday, for the prioritization. In the OTP, you received the response by the OTP, and I would like to give the floor to the OTP to give us, to present what you sent as a response yesterday. You have the floor.
Thank you, Madam Facilitator. Good morning, everybody. Indeed, we received this query last night to explain the priority areas that, after reviewing the recommendation for the CBF, the office considered most relevant to the discharge of its mandate. And we clearly indicated and reiterated, because it was expressed previously, that there are 3 areas that we have considered. And the first one is the country expert. As you know, it is important for each team in the active investigations that the office is conducting to have relevant knowledge of the situation. The ICC is not like ad hoc tribunals that can benefit from building up and creating economies of scales from cases in the same situation. It has to start over and over again every time there is a new situation. That complicates the matters. And in addition, there are cultural, historical, and political aspects that are key to conducting the investigation and prosecution and understanding the reasons sometimes for certain specific groups to become target of attacks by the factions at war. So it's really relevant for the office to have it. The CBF did recognize the need for that and approved or recommended for your approval a number of positions, 3 out of the 7. So for us, it's really relevant to assure that all unified team can progress at the right speed and deliver result, to have this kind of specific expertise in each team. Therefore, our priority is to have these positions. The other position that we indicated as a priority is in fugitive tracking. We have 17 outstanding hours. The office is working on additional suspects and possibility of requests to have issuance of hours in several different situations. And it's important for us to follow the fugitives and the suspects. Therefore, it is important to start building a structural function instead of borrowing resources from the team, depriving the team of investigator to have ad hoc temporary follow-up. No national institution would work like that in trying to track suspects. And we have plans to improve that even more in the future, but we need to start from somewhere, and this entails only one position. Finally, we had requested already in the last budget negotiation to strengthen the capacity of the Office of the Prosecutor, in this case the immediate office, to interact with stakeholders, namely states parties, oversight bodies, and also other organs of the court, to promote improvement and updates of policies and other mechanisms through which the court can improve the way it operates and the way it interacts with external stakeholders. Cooperation, and so far is one of the examples, and you've seen, if you were present at the discussion this morning, the IR recommendation. So to make that position structural to the office is key, and so that is the other area that has been mentioned in the answer by the office. Clearly, we do understand, and we read the query in that sense, that there was a request to have consideration for the limited resources. We do. And we do have already a reduced number of positions that have been recommended by the CBF, but mindful of the fact that we may have to be asked to stay within those resources, we will flexibly adjust so that these priorities that I just indicated can be accommodated within the envelope that is provided. We cannot right now tell you which position exactly would be the one offsetting another one, because that requires an analysis at the end of this assembly once the figures are settled and we can count on a firm budget. But this is the commitment of the office, has always been, using flexibility to stay within the resources given. In this line of thought, because we're talking about resources given, I would like to add one thing, which is in relation to what Ivan Alipi from the registry had just mentioned with regard to vacancy rate. Vacancy rate is something which is applied to established position to account for the churn, for the recruitment in normal times. It is the funds for salaries of established posts, which instead of being 100 in the case of the OTP, to use a round number, is 92 because of 8%. What happens in reality with the dynamics, and what we have experienced, is that during implementation there are things that happen. You see that in the proposal for the 2024 budget, the CBF acknowledged the fact that there is an increase that happened in 2023 of UN Common System, which is a contractual obligation. There was not in the approved funds of the budget of 2023. Therefore, the court had to absorb. How can you absorb an increase in salary of existing staff? By not filling vacant position. It's a managerial decision to ensure that the existing staff can continue to operate. But so the higher than usual vacancy rate is not a sign of a lack of will to high, is a sign of a lack of funds to hire, and the fact that funds are being managed properly so that the funds that you state are providing are used and no more than that. So it takes then leaving positions open, thus affecting the speed with which the office can progress to stay within the budget. Increasing the vacancy rate, and you see the amount that is at stake, almost 1 million, means depriving the OTP of the capacity. It's not helping, it's not curing the disease, it's actually making it worse, because it gives less flexibility, less capacity to act, because the funds are further reduced. Instead of giving 92, you give 90, and you still have a problem, and we know that there might be additional increases in new and common system which have not been considered within the envelope recommended by the CBF because they were just estimates. But it's likely to be the same situation that we had in 2022 and 2023. And also be mindful of the fact that the Office of the Prosecutor in 2023, so the budget for 2023, was only given the 2022 UN Common System and nothing else, not even the inflation on non-staff cost. Therefore, if you look at the implementation of the 2023 budget, you will clearly see it, even to cater for additional expenses due to the increased pace that is sought to progress in investigation and prosecution, which means witness cost, general operating expenses cost linked to the presence in the field, which means additional missions to expedite the investigation, had to call for additional resources not given, because on non-staff costs, not even inflation was given in 2023. Where did the OTP find the funds? By leaving vacancies. This is not helpful. This is not healthy. It's hampering the pace of delivery. So adding 2 percentage points more on vacancy is cutting capacity. So I advocate and urge you to consider the implication of such a solution or alternative. Thank you.
Thank you. I would also like to give the floor to the ICC presidency because, of course, these scenarios affect everyone. So you have the floor.
Thank you, Madam Chair. How to put it? The figures that were asked yesterday evening, the 10 and the 20% and the various types of cuts, insofar as travel is concerned, I'm going to express myself only on to this point, and if there are questions about other aspects, of course, I'll gladly try to respond. Need to be put into perspective. Of the 3 largest major programs of the court, 1, 2, 3, we are the MP1 is the smallest. Now, it is really important to understand why there is this increase in our travel request. And then you look on that basis, against that, you could see what's the effect of the cuts that are being proposed, whichever, I'm not getting into the percentage, but in general. The president the president certainly is meant to be the face of the court. He, she participates in cooperation and universality mandate of the court, contributes to that. So travels partly are linked to that. Another aspect of the travel increase, that's an ongoing matter, but the travel increase for 2024 is based on the biggest part of that, I mean, the significant part of that is based on the election of 6 new judges. Now, how does that impact? The judges will need to be brought, all of them, to the seat of the court for the solemn undertaking. Now we also know, before we didn't know, where the judges have been elected from, I mean, where they will be coming from. So that's something else to consider. Then on the 11th of March, they will have to elect the new presidency, the next presidency of the court, which will start its mandate on the day of the election. Unlike other elected officials, the presidency of the court, once they're elected, on the same day they have to assume their mandate. To do that, these judges, the 6 newly elected judges, need to spend a little bit of time to see who are they going to be voting for. That goes hand in hand with the induction program, which requires for the judges to be here and to understand, the administration of the court and many aspects of the court that you wouldn't see when you're outside of the court, which also is part of the recommendations of the independent expert review. So what our general increase represents is based on these factors, essentially mechanical factors. I would like to add something to this because the President spoke with me after we got this new request that Ivan read out to you and you have received. And he asked me to remind everyone also about this. This year, and that's an example that I've used a few times, this year the President was invited to an interministerial meeting here in September on the opening of the United Nations General Assembly. He did not travel, partly because we were unsure of the funds that we had in the budget line that we had. He did not. When he travels, he or she, because all presidents have done the same, when the president travels, he or she is accompanied by one staff member, one. And here also, you have seen, it's almost the same thing. It's 1 to 2 staff members. So we are already, to the extent that we can, also have been using measures that enables us to be responsive, as far as MP1 is concerned. I'm not speaking for the rest of the court, that we act responsibly when it comes to these expenditures. Also, another thing that the President reminded me is that for certainly the travels in Europe that he's had, everything has been done in the class of economy. Also, I would still add, for the 25th anniversary, when some of the judges were invited to Syracuse, everyone traveled in economy. You might have seen some persons from the judiciary here this year, some judges. I just wanted to be very clear, the court did not pay for their travels. The President has been, but not the rest. So I just wanted to give you a little bit of background in terms of where we come from and where humanly possible we've tried to exercise, to put in place measures that help us not to spend in a way that, to try to save money, essentially. Thank you.
Thank you. Okay, now that we heard the representatives of the court, are there any further questions, comments, or queries while the representatives of the court are here with us? I give the floor to Sweden.
Thank you, Madam Chair. Thanks for all the representatives from the court for being here with us and explaining on the figures. And it's we can only commend, I think, the judiciary for limiting the travel expenditures. I had a question to Ivar Arpi with regard to one of the figures concerning the ACN and the legal officer in one of the columns regarding the secretariat. It says that the number is 102.4, and I was wondering if I could have the exact numbers for what is with regard to the ACN and what is with regard to the legal officer. Thank you.
Thank you. Are there any other requests? Because if there are a few to... Kenya, you have the floor.
Thank you, Ambassador, and thank you to the court officials for their presentation, especially given the request was last night. We do appreciate it. I particularly want to appreciate the presentation on the 20% travel reductions. This is very much welcome in light of the austerity climate that we experience on the domestic level. With that being said, I still have a question, particularly, I suppose, for Mr. Alipi, with regard to the MOCOM impact. I would like to understand why the MOCOM impact is only catered for in the registry and not reflected in other programs. So that's one question. My second question is with regard to inflation. I want to understand if this aspect was factored in or not. I know the CBF recommended that it be absorbed, so I want to understand if these figures are reflecting that. And my third question is specific to Mr. Marco with regard to the Office of the Prosecutor. Correct me if I'm wrong, but I do not see your cost. I see your priorities, but I don't see the cost associated with these priorities. And could you clarify if the Office of the Prosecutor at this point in time, these priorities, this is the focus and not, in quote, the restoration of the CBF figure? I don't know if I'm clear, but yeah, okay.
Thank you. I give the floor to Norway, to be followed by Brazil.
Thank you very much, Madam Chair, and I would also like to thank the court for these very useful clarifications, both with regard to the vacancy rate. I think it was a very, very useful clarification you gave there, and something that we really need to bear in mind. That this actually means reduced capacity and not only a calculation of vacancies that just happen, but it's actually a calculated vacancy due to shortage of funding, and this is something that we would have concerns about. I have a question with regard to the travel reductions. Norway has expressed earlier that we do see merit in a review of the travel policy as well as the practice of the travel policy. For us, it's vital that travel policies are being adhered to. I would like to ask, with regard to the proposed saving of 20%, that's a very large amount. To what extent would a review or a revision of a travel policy or more strict practice of the travel policy actually mean a saving of as much as 20%? It's, in our view, important that the court is able to travel when there is a need for the court to travel, but at the same time to have a sober practice. Would you be able to just clarify that this is actually a realistic figure without having to skip travels that are important for the court to do? Thank you.
Thank you. I give the floor to Brazil, to be followed by the UK.
Thank you, Madam Coordinator, and I would like to thank the representatives of the court for the information that you promptly provided, which is very useful. And I have a question to the distinguished representative of the OTP. Thank you for the explanations on the vacancy rate, but I would like to, if you could elaborate a little bit more on how you arrived at the number of 8%, because there was a very sharp decrease from 2023, from 17% to 8% in 2024, whereas for the judiciary and registry, the variation was considerably lower. So if you could provide more details about this, I would be grateful. Thank you.
Thank you. I give the floor to the UK, to be followed by Germany.
I'd just like to reiterate our thanks for the court providing these useful clarifications. I think we now feel much clearer on the vacancy rate and are quite concerned that applying a 10% vacancy rate would prevent recruitment into key positions and have an impact on the investigations next year. I'm still slightly less clear on the travel, and I would appreciate if the representative of the OTP could outline the impact of the reduced travel budget on the OTP. And I also second my colleague from Norway's wider question. And then finally, just so that we are all on the same page, I think it would be just helpful, again, if our colleague from the OTP could just outline the figures that are involved in what the requests are. So I understand from having a look at the CBF figures and also the budget that as it was presented, that I think what's being asked for, and apology, this is obviously where my laptop has collapsed, is an increase of around, if those positions were to be filled, those 7 in additional positions, we're looking at a suggested increase of around 14.5%, and the CBF proposed increase was 12.8%. So I just think it's worth clarifying that, just so that when colleagues are talking afterwards, that's what we mean. Is that the case? Thank you.
Thank you. I give the floor to Germany.
Thank you, Madam Facilitator, and thank you to all the representatives of the court for their helpful explanations. A brief technical question that I may just have missed the answer of. We were sent 2 tables that slightly differ. As far as I can tell, the one that we received just prior to the meeting only differs regarding the figure of the Secretariat, and it is lower by 204,700. Just for my understanding, would be helpful to elaborate where that change comes from. Was it the earlier table just not calculated correctly, or was any substantial change made? Thank you.
Thank you. Would anybody else like to take the floor at this point? If no, I will invite the representatives of the court to respond to the queries raised.
Thank you. Thank you for your questions and comments. Starting from Sweden's question, the 2 amounts for the total of 102.4 that you see as an increase for the Secretariat correspond to ACN meeting 22.9 thousand, so 22,800 euros, and legal office 6 months 79,500. Now, moving to the questions from Kenya, no, the inflation of 3% is not included in the numbers that you see here. You may recall that the CBF recommended not to approve this increase. Therefore, this table does not include the 3%. I will leave it to my colleagues, Hirad and Marco, to explain the resources following the withdrawal of the charges in the Mokon case. Just for the registry to recall that also the registry retained some resources for legal aid since the case is terminated, but there are still some activities ongoing, and therefore there are some resources that are retained, and the reduction of 941,000, 43,000 is what we could return. It has to be noted also that the CBF had reduced some of the resources attached to the delivery of judicial activities in the 3 courtrooms, and these overlapped with some resources requested for MOCOM as well. So the amount for the registry is the one that you see there, and perhaps Hirad and Marco can elaborate on the OTP and presidency. Talking about now travel policy and the reduction of 20%. You know that the travel policy of the court is strict. It allows for business class only for elected officials, and all the reminder of the officials of the court, staff of the court, travel economy class, and there is economy class comfort only beyond 9 hours of travel. You also know that we presented in The Hague the split of the total budget between those trips that are more predictable, where the court could do better and could perhaps save some resources, and those other operational trips where it becomes more difficult to have predictability and therefore costs are a little bit more higher. All in all, we see that with a reduction of 20%, we go below the level of 2023 approved budget. So that's a little bit concerning for us. Indeed, we're going to work towards continuous improvement as usual, and we will strive to save as much as we can in travel, but we see definitely the 20% being problematic. There was a question from Germany on the variance in the Secretariat ASP's total budget. We apologize. That was a mistake in the table that you saw earlier. The first version sent out included the resources, the 102,400, rather than in addition, it was in reduction. And therefore now by adding, you see double increase. So that's the explanation. I would hand over the floor, with your permission, Ambassador, to Hirad and Marco to complete the question on MOCO. Thank you. And to follow up on the other questions for the OTP. Thank you.
Thank you. And I'll be very short on MOCOM. Actually, in September, when we already had the first session of the presentation of major programs, I already informed everyone, and I will do it more formally here, that upon the withdrawal of the charges against Mr. MOCOM by the prosecutor, the position of the judiciary, it's not that it changed. We had already mentioned that in the proposed program budget, we renounced essentially the calling of all 6 judges on a full-time basis. That is so because we had already said in the proposed program budget that all 6 judges would need to be called if the charges were confirmed against Mr. MOCOM. Since in any event the prosecutor withdrew the charges, so we had to be consequential and coherent from what we had said. We did that transparently, and therefore 3 out of the 6 will be called. Which 3, I don't know. That's going to be for the next presidency.
Thank you, Madam Facilitator. Thank you for the questions raised. I jot them down. If I, by any chance, overlook one, please do remind me. Starting from the question asked by Kenya, the cost of priorities. The cost of the 3 priorities area and the people involved in that is around 950,000 euro. So that is, again, less than 1 million in terms of the total increase, and is for those positions that I mentioned. And again, as I explained in my previous intervention, ideally this would be a small sacrifice to provide the capacity that we request to priority figures. We do understand the difficulties and the concerns of some states about increases. So we always, the court and the OTP in particular, stay within the budget, even at the cost of leaving positions vacant. So we will, if it is not possible to make the effort, we will reconsider the positions that have been recommended by the CBF, because they go into the GTF funds, and clearly they will be absorbed into that, and decisions will be taken. Right now, I cannot exactly tell you which ones, because one thing that must be clear is that even within the reduced number of positions that have been recommended by the CBF, there are important positions to allow the office to go on with investigations, with prosecution, and with field presence. Therefore, any sacrifice, any offsetting will be at the cost of something else. It's not indifferent. Therefore, it requires an analysis done so that in case it's not on top of what you're currently considering, it will have to be absorbed. I hope this addresses your concern in that area. The second point about travel, as Ivan mentioned just before, I read the date, it was November 10th, the court provided the two annexes on travel expenses, and in particular provided the split between the operational expenses linked to, for the OTP mission, and those that can be considered more predictable. The aim of the split was to provide the states with an indication of what missions could be planned in advance, thus allowing for savings. For the OTP, the total cost, I have it in front of me, is 76,700 euro out of the request of 2.6 million. So that is the proportion that we are talking about. The 20% clearly would eat up on the missions. Yeah, it would eat up 20% of 76.7 on, let's say, official missions, not linked, let's say, the prosecutor attending the African Union meeting or the UN Security Council here in New York, when he doesn't do it in video link as he's recently started doing. But the rest will impact on mission. So it will reduce the capacity to deploy. And 20%, in addition to the cuts of the CBF, will probably bring the level of the funds for travel below the approved budget of 2022. So 2 years later, with more activities to do, less budget for operational missions. So definitely, there would be an impact if that is the decision of the states. The question from Brazil about the vacancy rate, in terms of the vacancy rate, is an historical trend that is calculated in regular times. So what would be the churn, the rotation of people that happens while business as usual, not in exceptional times? You may have noticed that there was a very much lower churn during COVID. People were not leaving the organization, they were staying in the organization, so the vacancy rate decreased. Yet, in the budget proposal, we stuck to 8, which was a more relevant historical figure. So in preparing the budget, we try to take into account the reasonable and historical trend to guide us, not percentages that are influenced and affected by exceptional events. In the case of the 2023 budget, and even a 2022, is the fact of the UN Common System increases that were not factorized into the approved funds given to the court, and so the OTPE had to manage. And so the managerial choice made was to leave position vacant so that operations could continue, and the existing staff could be paid according to the contractual obligations incurred by the court with the contract. UK, yeah, I think I've addressed the vacancy rate already with my answer and the travel. Indeed, yes, the additional request would bring from 20.8 something, 20.7, yeah, 20.8, the increase proposed by and recommended by the CBF, to less than 2 percentage point increase. It's 14.6, 14 point something, depending on the salary scale that is being used. Finally, on MOCOM, the Office of the Prosecutor had requested one additional position that the CBF did not recommend. So already, when the decision to withdraw the charges was taken, that resource was no longer in the package. The reason for requesting only one was that there are other two situations that deal with the same situation country. The intention of the office was to request new resources, which was the proposed budget by the office, for the situation that had developed and they were understaffed, and to redeploy resources from the other two trials to the MOCOM case, plus this additional one. Now, having had recommended reduction in the number of new positions, the office has to reconsider how to redeploy. So, in a way, the fact that MOCOM doesn't exist allows the office to redeploy the resources in the other two cases in Central African Republic to the investigations and to the other activities that would have been strengthened by the addition of new resources. So there is a change, which is a typical dynamic evolution within the life of the court and the office in particular. So that's why the impact on the recommended level by the CBF for the office was zero, because the only resource, new resource that had been requested had already been not recommended, so was not included in that. And with that, I rest my case for the moment. Thank you.
Thank you. I would like to thank now to the representatives of the court for being with us in this meeting to give further responses and clarifications to be fully clear about all the information we received last night. Thank you very much. And now we will continue in the states parties only format, so we will give a couple of minutes to the representatives of the court to leave. Okay, I think we can continue. The representatives of the court left. Okay, so this is what I propose we do now. now you have all the scenarios, all the information. I would like to invite a sort of tour de table, I mean whoever of course wants to speak. I would kindly ask you to avoid long speeches, because we had the last 3 days doing that, so I think everybody's pretty clear what the priorities are. So just to limit yourself to saying, I mean, as much as it's possible at this point, we will of course continue in the afternoon as to what is acceptable from and which scenario, if any of these are acceptable, and if not, what is the alternative. So please limit yourself to that instead of, again, giving a long reasoning for such a position, because it's pretty clear where we are. I open the floor. I give the floor to the Netherlands.
Yes, thank you very much, Ambassador. I have a preliminary question concerning the scenarios that were presented. So on the table, we have, for example, the OTP vacancy rate reduction, which was raised, I believe, by one delegation, whereas the OTP priority positions, for which there was a lot of support during the meeting yesterday, were not included in the scenarios. I wondered what the reason is for that, and whether there will be new scenarios calculated by the court, and how these will be presented to the states parties. Thank you.
Do you want a new scenario?
I think it's useful that we have scenarios, including the points for which there's a lot of consensus.
You mean a lot of support? Thank you. To be clear on this, please specify which scenario you want, so that we can be very precise by asking that scenario from the court, because it needs to be produced within the next couple of hours.
I would suggest including the priority request from the OTP, and I believe also the positions from the Trust Fund for Victims. It should at least be included in options that are presented to the delegations.
So to be clear, the priorities that we received from the OTP per request by Kenya yesterday, these ones, right? Yeah, because I think we even have the figure for that, because it was specifically asked now while the court was present. So I think it's pretty easy to, I mean, if you want the scenario, of course, we will ask for it, but I think they said, please remind me, but they gave, somebody asked, so they gave the exact figure for these positions.
Yeah, it's 950,000, I know that, but yeah. My request is, if a new scenario will be presented, to please include those items for which there is a lot of support, and not items for which there's no support yet.
I give the floor to Brazil.
Thank you, Madam Coordinator. I'll try to be brief. With regard to the question posed by the distinguished delegate of the Netherlands, I understood that the representative of the OTP said that the positions would cost around 150,000 euros. And then the reduction in the vacancy rate would amount to more or less 950,000 euros. So it's and nowadays there is a vacancy rate of 17%. We are just proposing a reduction of the vacancy rate to 10%. So they will have the ability to hire more people. It won't affect. And I have to confess that I was not convinced by his explanation. It was not detailed enough why they chose the specific figure of 8% for 2024. So that's our concern. We are not, I want to be clear, we support the OTP, we support that we support that every possible violation of international criminal law should be investigated, and therefore we support the OTP. We made a huge contribution in the last 12 months. We gave the court more than 22 million euros in our efforts to fully comply with our financial obligations before the court. And the ministry, it's not even the Ministry of Foreign Affairs, but the Ministry of Economy, which tends to be less sensitive to specific requests, they want something returned. They want to be strict. And I see in the scenario that the court kindly provided this morning that in any way, in the worst scenario for the OTP, there would be an increase of 10.2% in their budgets. So it's nothing, it's not draconian what we are proposing. Thank you.
Thank you, and I don't want to jump into your bilateral debate. Just wanted to tell the Netherlands in response. There was a proposal by Ireland and the group of countries in which you were also yesterday. It encompasses all this that you asked for now. And that proposal, of course, garnered support yesterday. We heard it from a number of states parties. On the other side, we had the proposal of Canada and Mexico, which also garnered support. The scenario you got last night is the middle ground between the two. And this also responds to your question. So this is not about getting this amount support here or this amount support there, but presenting all possible options. So, and as I said at the beginning of this meeting, the proposal by Ireland and the group of countries was also circulated before the responses were. So it was circulated immediately after the meeting we had yesterday. So just to add up to the response, I give the floor to Kenya.
Thank you, Madam Ambassador. And so I'll just start with I was not particularly convinced by the MOCOM distribution, but willing to live because they've demonstrated that there's a 943,000 saving in there. But more concerning is I think we have to make a decision around the travel reduction, the travel savings as we see it, because there's a lot of merit in 20% reduction. I think this is one particular area that I would seek your indulgence in finding an answer. Let me put it this way. So it's either there's a lot of merit in redistribution of resources around 20% travel reduction, and as explained by the court officials, I didn't quite hear any suggestion that there would be a deep negative impact on mandate delivery. So yes, which is to say I am pro 20% travel reductions.
Thank you, and I will note it as such, because I'm certainly not going to make any such decision. It's the decision of the states parties, so a consensus needs to be built around any of the two possible, because we asked the court to provide two scenarios because these two scenarios were mentioned yesterday in the meeting, and this is why we asked them to provide these two versions. But don't ask me to make that or any other decision in that regard. So if anybody else has similar ideas, I discourage you from that immediately. I give the floor to Mexico, followed by the United Kingdom.
Thank you, Ambassador, for giving me the floor. First of all, I would like to thank you for the new proposal from Ireland and the group of states supporting the new 5%. But unfortunately for Mexico, the CBF figure seems to us to be quite high. And the second scenario of 9.5, we think it's even higher still. Bearing in mind our financial capacities, unfortunately, we will not be able to support that proposal for 9.5%. Thank you.
Thank you. I give the floor to the UK.
Thank you, Madam Ambassador. Just a point on travel. I think, as a colleague from Norway said, it's important that it is well justified, and I think we've heard different justifications for the court today, and hopefully an increased willingness to also use virtual meetings. But just on the point of impact on operations, I think, as our colleague from Sweden was trying to get at earlier, it appears that there might be some impact on operations, specifically for the Trust Fund for Victims, on a very large cut. And then also from what I heard earlier on the Office for the Prosecutor as well, it sounds like this is less about the prosecutor being able to go to places, as I think we would probably agree that some virtual options are sensible, but more about victims being able to come and provide testimony, or the investigations. It seemed to have an impact, they were saying, on the kind of operational side of investigations. So I'm wondering if we can come to a compromise position which both recognises that we need a justifiable travel budget, which is aligned with current economic situations, but that also enables some of the more operational aspects of the court, like the trust fund and like the OTP investigations to run. So that's just that. Thank you.
Thank you. Would anybody else want to take the floor? Slovakia, you have the floor.
Thank you very much, Madam Facilitator, for giving me the floor, and I would like to thank for presenting the scenarios. We believe they are quite realistic and encompass a lot of priorities presented here during the last couple of days. Now, on the issue of travel, as you know, yesterday my delegation suggested a 10% cut. To that, I listened very carefully to the explanations given by the representatives of the court today, and they did not seem too convincing to me, at least. And also we know how these travel figures are budgeted for. I mean, we discussed it quite in depth in The Hague. So we really believe that if a cut is made, it will not have an effect of lowering the number of trips. It maybe just the court needs to really do it in a more efficient way when organizing them specifically. Now, the last comment I wish to make on the travel, we have two proposals or two scenarios, 10 or 20%. I just wish to know that there is a lot of other numbers between 10 and 20, or even beyond this range. So I'm sure we can then in the end agree on one. Thank you.
Do you have a specific proposal as to the number in between? No. Okay. Germany, did you want the floor? No? Anybody else? Australia. You have the floor, followed by Austria.
There we go. Thank you very much, and thank you for the quick work overnight. It's very helpful to see these figures and see the key priorities identified, and to use the CBF as the base. As was emphasised by many yesterday, I won't repeat, the CBF is an independent technical assessment and is very useful to be the basis for discussions. And we welcome this proposal shared. We see that the very practical savings suggested were also factored in on travel, and see it as a constructive way forward. At this stage, we can be flexible on the percentage of that travel cut, provided it doesn't impede on the key operational requirements of the court's programs. And hearing from the court earlier, 20% seems problematic to deliver on the court's, the major programs, operational mandates in particular. But we are open to hearing further on this and looking at what a realistic travel savings figure would be. And also on the OTP vacancy rate reductions, after hearing from the OTP today, we also had some concerns around the practice of continuing to absorb unforeseen salary increases through not hiring people and leaving additional vacancies, and that slowing down investigations. So we'd be very cautious about changing the vacancy rate in that regard. We're quite conscious of not cutting the OTP's rate from the CBF technical assessment. So without going on for too long, so we can keep this short, we look forward to continuing to engage constructively and flexibly toward reaching a consensus as soon as possible.
Thank you. I give the floor to Austria.
Thank you very much, Madam Coordinator. And first of all, I would really like to thank you for your patience with all of us here. I know we're not an easy crowd to work with. Also, let me thank you to everyone who was working hard last night to provide us with this additional information and the scenarios. It is really very helpful for us to have that on the table. In the past couple of weeks, we have repeatedly stated our priorities, and I will spare you not repeat all of that, but I just wanted to say that for us, the scenarios circulated last night reflect our priorities as well as the common priorities we have identified as a group here. We also listened carefully to the concerns of others, and we really appreciate everyone's openness in our conversation, and we see the need for further efficiencies and savings. So we can support suggestions to reduce the court's travel budget further. I basically just want to, voice our support for your work, for your attempts to bring us closer together and to find a compromise. And we welcome the proposals as a basis for the further discussions. From what we have on the table right now, I think option B seems a bit too low for us, so we would rather welcome further discussions based on option A. We think it is a well-justified proposal. It seems balanced, and in our view, it could provide a basis for compromise and a possible landing zone. So we're happy to engage further negotiations, show our utmost flexibility, and hope we can reach consensus under your able guidance very soon.
Thank you. I give the floor to Denmark.
Thank you very much for giving me the floor. I'll be extremely short. Thank you to you, Madam Ambassador, and your team, and also, of course, the court for all the hard work you put in last night to provide us with these new scenarios. We could, in the spirit of compromise, we could probably consider supporting any of the two options, although we do agree option B might be a bit on the low side, but we could also go along with that. Something along the lines of option A would be, we would welcome something closer to option A probably. And we of course welcome that many of the scenarios elaborated on this proposal are based on the CBF calculations. Thank you.
Thank you. Germany, now you do want the floor. I give the floor to Germany.
Sorry, and thank you for giving me the floor. I did press the button a couple of times too many. Thank you very much. I think we are nearing the final stretch, and we are very pleased to see that the numbers are coming closer together, which is to a large degree thanks to you, Madam Facilitator. So thanks for your leadership on this issue. The tabled proposals are very helpful, and I'm grateful that many delegations are taking a serious look at the proposals. I do believe that we would be able to support travel cuts of 10% and going beyond 10% it might also be possible in the spirit of finding a compromise, although this is obviously nearing the area where cuts will be quite painful. Speaking of painful cuts, the cuts that were proposed by Brazil, certainly, as we heard from the court, seem to be something that would be tough to absorb. The rate from increasing from 8 to 10%, that represents almost 1 million for the court. But maybe this is a time for painful cuts, as we've heard. On the other hand, the increase or the priorities of the OTP were well reasoned. Ideally, it would have been helpful to hear an explanation of the entire portion of the OTP's budget and the priorities and a costed one. But we are happy to hear that the priorities for fugitive tracking, the priorities for country experts seem to be a shared priority by many. That seems to make eminent sense. So this might be a way of actually providing the OTP with the resources that it needs, and it might be an interesting coincidence that these two numbers seem to be in the same realm. I think it's about a 50,000 euro difference, or a bit less even. Yeah, that's certainly interesting. So we remain our preference is to finding a solution soon and remain flexible, and are ready to speak further. Thank you.
Thank you. I give the floor to Sweden.
Thank you, Chair. Thank you for these scenarios. They're very helpful. Sweden would want to avoid doing any cuts on the operations of the court that we find very important during this coming year, that the court will actually have quite a, especially the OTP, will have an increasing working load with regard to several big investigations going on and maybe new coming in. I know this was a suggestion I made yesterday, and at least a small cut, but I would suggest that we cut the 22,900 from the ACN. I would suggest a virtual meeting should be sufficient, given the fact that a very low number of submissions have come in, and maybe a in-person meeting could be postponed till next year when more submissions have, when there are actually more submissions to discuss, and at least that's a small cut with regard to travel, and I haven't heard any state party arguing for keeping this cost or mentioning the ACN as a priority for them. Thank you.
Thank you. I give the floor to Finland, to be followed by Belgium.
Thank you very much, Ambassador, and thank you for the documents and scenarios provided overnight. It's very helpful to us that the scenarios build on the CBF recommendations, and I'll just make a couple specific comments. First, on travel, we welcome the two scenarios, and we agree that some reductions can be made. We just heard from the OTP that the 20% cut would be problematic, in that they would eat up official missions and capacity to deploy. So this would have a clear impact. So we'd prefer to take a bit more cautious of an approach there, considering that the cuts would apply to operational travel. On the OTP's budget, we're happy to see the CBF recommendations included in the scenarios, and We share the concern voiced by some colleagues about the application of a higher vacancy rate. We do think that if we got further, we will only exacerbate the problem that they currently have. Furthermore, it is important that we continue discussing the OTP priorities, which we now all have on paper, so that we enable the OTP to meet the states parties' expectations next year. Thank you.
Thank you. I give the floor to Belgium.
Je vous remercie, Madame.
Thank you very much, Chair. On our side, I think that Belgium could be flexible if needed in terms of the travel reduction, even if we would prefer option A by a long way. However, we would be more reluctant to increase the vacancy rate at the Office of the Prosecutor, even more so if there's no follow-up given to the priorities asked for by the Office of the Prosecutor. But we would support giving the office the few proposed positions that were discussed this morning. And finally, on meetings of the advisory body for judges, the ACN, I think that we could also be flexible if there was a question of reducing their budget. Thank you very much.
Thank you. Anybody else at this point? Oh, wow, 3. I give the floor to Poland, to be followed by Mexico.
Thank you so much, Madam Ambassador. Many thanks, as always, for your able leadership, and also thanks to your team, because I think that Maria and the Secretariat truly are doing an amazing job. I thank the court for very much, actually, for preparing a very clear overview of scenarios that reflect the priorities of the vast majority of states parties. And I thank you, Ambassador, that you actually made sure that these concrete figures and scenarios are in front of us. We hope that the compromise will start to build around the figures presented in the tables provided by the court. We think that these figures also reflect the priorities of the court, the priorities that have been reprioritized at our request, but still. Our preference is for the scenario A, especially because we are a bit concerned that especially 20% cut in 20% further cut in travel expenses for the MP1 may be a bit too painful. I made a comment yesterday about the small major programs that usually suffer most if we reduce their budget, and the MP1 is of course not a small major program, but it's smaller than MP2 or MP3. So yeah, preference for scenario B, but we remain flexible, and we also want to thank all the delegations who already showed flexibility to an extent that probably, I don't know, 2 weeks ago was not even in our minds. So thank you so much for that, and we truly hope that we can have a good compromise today. Thanks.
Thank you. Just to clarify, but I'm sure it was an accidental mistake. You said preference for scenario B. Scenario B is 20, so scenario
no,
A.
A, sorry. Yeah, that was. I'm so sorry.
This is what I gathered from your entire intervention. So yeah, scenario A.
Thank you so much. I'm so sorry for that.
No problem. I give the floor to Mexico, to be followed by Brazil.
Muchas gracias. Thank you very much, Ambassador, for giving me the floor once again. I just wanted to say 2 things. Our preference would be option A. We can be flexible in this regard. And I would also like to echo what was said by Sweden with regard to the fact that the ACN doesn't need to actually meet in person next year. Perhaps they can meet virtually instead. That would lead to savings, which can then go directly to the prosecutor's office, hopefully. Thank you.
Thank you. I give the floor to Brazil.
Thank you. Excuse me for taking the floor again. Just for the delegations which are concerned over the vacancy rate. I just you have to agree with us that there is some strange calculation on the part of the OTP, because the elevation of the vacancy rate to 10% would entail a cut of 950,000 euros. And then they said that the priority positions that they are asking for would cost 150,000 euros. There is a huge discrepancy, so they don't need such a low vacancy rate. So, and anyway, it's much better than the vacancy rate that they currently have of 70%. I just wanted to make this remark. Thank you.
Thank you. Belgium, you have the floor.
Oui, excusez-moi.
Yes, apologies, Chair, for taking the floor again, but listening to my Brazilian colleague, I'm not quite sure about the figure that was given, actually, by the registry, or pardon, by the OTP, that the cost of the priorities listed, the few posts that were listed, it was 976,000 euros. There was something that I didn't get. Could we have the figure again that was provided by the Office of the Prosecutor in terms of for the priorities that were listed? Could we have that figure again? Thank you.
Sure, yeah. It was somewhere around, as far as I know, 900,000. And to build up on that, in the meantime, while listening to all of you very carefully, I looked again at the Irish proposal, Irish and others proposal, and this is a follow-up to the question of the Netherlands. So exactly the same positions that are listed in the priorities submitted by the OTP are listed in your proposal. So it says additional resources for the OTP above the CBF recommendation, including 4 country experts, fugitive tracking, a senior trial lawyer, and an incumbent advisor. So I cannot agree with you that we didn't get that scenario. That scenario is your proposal 9.5. It's there. I mean, it was circulated last night. So it's CBF and with all the pluses. There is security and others, of course, but for the OTP, this is what it says. I'm reading from your proposal. You have the floor.
My question was, why is the OTP vacancy rate reduction included, although there was not yet support for that yesterday, and I do not see a lot of support for it today? And why were the OTP priority requests not included in the scenarios? That was my question. Thank you.
And I will respond to you again. Because what was included in the scenarios we got today was all the requests made yesterday, including, for instance, the ACN, which obviously has no support at all, but is also in the scenario. And it might be cut from that scenario. So that is why all the others, and it is not the question of support. So I'm not dividing requests by support. I simply take all the requests by states parties and get them into the scenario. That is the answer.
Yeah, please correct me if I'm wrong, but the OTP priority requests are not in the scenarios, right?
The only request that was made today was for the OTP to provide their priority list. And only today, when they did so, there was a question how much money that is. And we got the response from the floor, from the OTP. I give the floor to Chile, to be followed by Brazil.
Gracias, señora.
Thank you very much, Madam Chair. We're grateful for the efforts that have been made in presenting these new scenarios, and we'd like to thank the Secretariat, of course, for these new figures and providing them in such a short space of time. Yesterday, at the end of the meeting, you summarized what had been discussed and the topics that were going to be included in these scenarios, and those are now summarized in the document, we think. So we think we can work on that basis. On the options that are available, I'd like to thank Brazil for their proposal on the vacancy rate. We have heard quite a bit about that, and we think that the figures on the table in the document have a basis that is more acceptable to, hopefully, to many delegations, and those delegations who would have difficulty accepting an exponential increase in the budget for 2024. So hopefully that will help us to move forward. Given that there don't seem to be any major difficulties in further cutting travel costs, we can agree with option B, that is to say, a 20% cut. We think that would leave the definitive increase at 7.8%. We think that would be where we'd end up, a 7.8% increase. We think that's nevertheless quite a significant increase for next year. Thank you.
Thank you. I give the floor to Brazil, to be followed by Sweden.
Thank you, Madam Facilitator. My apologies again to take the floor. And thank you, the distinguished delegate of Belgium. That's why I believe the numbers provided by the Office of the Prosecutor don't match. Because reading the paper, the replies that provided yesterday, they said that they proposed 7 additional positions. The CBF recommended only 3 for approval. And then this, if these 3 priority positions would amount to 970,000 euros, I want the salary because it's very high. So I don't believe it would refer to these 3 priority positions. When he was asked about the priority positions, I understood, and I may be mistaken and apologize if it's the case, that the priority positions would amount to 150,000. Maybe I'm wrong, and somebody corrects me. So they play with the numbers because they say they need 7. It would cost. The 7 would cost 970,000 euros. So they are not transparent about this because they want the resources. It's natural that they do that, but our task here, it should be strict to fully look into detail what they are proposing. Thank you.
Thank you. Now I'm warned twice to tell you that we are losing. Actually, we have already lost the interpretation, so I really thank the interpreters. They deserve a break. And I suggest that we continue until 1:30 so that everybody can have a lunch break, and then I guess we can continue right after the plenary. The plenary should be short in the afternoon, right? Just to table the resolution, so agreed so far, so we can continue immediately afterwards. I have the United Kingdom and France on the list, so I give the floor to the United Kingdom, to be followed by France.
Thank you, Madam Ambassador, and I think my colleague from Brazil is correct that the priority positions that were in the document that was circulated from the OTP do not amount to 150,000 euros. And I also agree that understanding the figures attached to that document were a little bit difficult, which is why I sought clarification from their representative in the previous meeting. And what the representative stated on the basis of what we were seeing on the set 3 corrected, so just that's the one labelled ASP22 budget informal set 3 corrected. They were responding in the fact that the line on major programme 2 OTP is a budget recommended by the CBF, so I think that's to the side. The positions that they were talking about were in additional to that, 7 additional positions, which come to what they said in the meeting before was around 950,000 euros, and I think I understand the exact figure is 976,000. So that's what I think they are talking about. So the question around the vacancy rates, as I understand, is around the sort of the previous figure. So they would obviously like, in addition to the CBF, they've articulated a rationale of why they need additional positions, but that's not to do with the vacancy rate. My understanding is that the vacancy rate is about the sort of CBF recommendation and the wider picture, which is that they have to cope with some gaps in their budget. They aren't able to recruit into positions. So if that makes sense, I think they're slightly different issues. So the priority positions that they would like on top of the CBF figure come to around 950,000 euros. And then what they're asking for separately is that the vacancy rate is not reduced, because that will mean gaps in their existing capacity. They won't be able to fill key positions for operations next year. So I think, we obviously understand the positions of that people have raised separately about difficulties going above the CBF, and I think, but I think the concern on the vacancy rate remains for us. Certainly, having heard the response, we're worried about the impact on operations, and also I think it just is for better transparency if we resource the positions and this sort of more creative accounting to backfill a lack of resources then doesn't happen. Hopefully that was somewhat clear, but apologies if not. Thank you.
Thank you. I give the floor to Franz.
Thank you, Madam Facilitator. Merci. I had my speaking notes in French, but now I tried to. So please bear with me if I search my words. But and I will follow your advice to be concise and practical as much as possible, so that it's clear. We had very much sympathy about the proposition from the CBF, the recommendation from the CBF as transformed in the scenario C, and we were and we are in favor of giving more resources to the OTP, as several delegations we are joining, and also on the Secretariat and the Trust Fund of Victims, we are in favor in having more resources on it. Talking about the recent options about the travel costs, we were in The Hague and here very much in favor of having cuts on this, because we were not convinced about the way the court was using this resource. There was 50% cuts proposed by the CBF. Now we have option less 10, less 20. We have interrogations about how it would impact the operational capacity, particularly, for example, for the OTP, if we cut too much. So, of course, between the two options, we are more in favor of option A, yes, with less 10%. B, voilà. About the ACN, we're ready to support one meeting in person and one meeting in video conference, but we have also sympathy in having all the meetings next year in video conference to find some savings. That's where we stand, and maybe just a general comment about the vacancy rate. We're a bit concerned. It's used as budgetary policy. It shouldn't be. This is a human resources question. But I hope we will be able, with this new budget, to give some leeway to the court to have a proper human resources policy, and not using this as leeway in managing the budget. Thank you, Madam Facilitator.
Thank you. Anybody else now? If not, before we continue so that we can work on the figures, I would like to resolve the issue of the ACN. It is my understanding that the notion is to cut these expenses, so basically not to allow any in-person meetings next year. Does everybody agree with that? If yes, then that makes a further saving of 22,800, as was said. So we will ask the court to further calculate it, although I don't expect it to really significantly affect the percentage, but 22,800 less. Now, talking about scenarios, we have scenario. It's the A version. I mean, at least this is most of the preference is heard. Although Kenya said they prefer the 20%. So these both options are still on the table. Then we have the scenario of 9.5%, which was presented by Ireland yesterday, circulated to everybody, and there also the priorities of the OTP are calculated. So to reiterate, additional resources for the OTP above the CBF recommendation, including 4 country experts, fugitive tracking, a senior trial lawyer, and an incumbent advisor. So please read. I know it's difficult, we are in the last days, but please read all the documentation that is being circulated. So we have 9.5 with all the priorities of the OTP above the CBF level. We have 8.1 or slightly less now with the ACN, which revolves around the CBF. Just for the sake of clarity, if vacancy rate were not to be included in it, it would raise this scenario to that's 1 million, which is 2%. I will have to check, but in that case, with 10% of travel cuts, that would bring us right to 10%, and without vacancy rate. So I'm giving now, because according to what I see here, 1 million is 2%. So 10.1 or 9.2 in the scenario B, with 20% cuts in the in the travel. And we have the Mexican and Canadian proposal. So these are the three. And I intentionally gave you these corrected versions so that you have all the information. If on top of the vacancy rate, we would include, but I suppose these, as the priorities are in staffing, that would practically balance out. I mean, that's my assumption, but I'll confirm it with the court. So, thank you all very much. As I said, we continue immediately after the completion of the plenary session, which will start at 3 and hopefully be, hopefully not more than half an hour, so around 3:30 approximately we will reconvene. Oh, and one more thing, very important. One thing I wanted to inform you. Since departing from The Hague and our discussion on the IR recommendation 140, I remind you that the silence procedure was broken before we came to New York. I continued together with Canada as the coordinator here in New York, extensive consultations with the states parties concerned. And I need to inform you that unfortunately there is still no consensus on this issue. So regarding the IR recommendations that needed to be assessed by the budget facilitation, the final score, I mean, if I can put it that way, is that we assessed 2 out of 3 recommendations. Also, I remind you that the arrears recommendation is the joint one between the New York working group and the arrears facilitation and the Hague working group. So I do hope that New York will be able to find a suitable person and the person willing to take arrears facilitation next year and continue these discussions, and I wish them all the success in that. And I do hope, especially now that the review mechanism is continuing for another year, that next year that recommendation will be assessed as well. I wish you a good lunch break. Thank you.